session. Can you confirm me if my screen's visible to everyone and if the audio is audible? All right, thank you, Soumya. All right, so we're going to start with international contract drafting. And as noted by the introduction, as I got from a lot of you yesterday, I assume that we all are new to the concept of drafting in general, rather than just talking about international contract drafting, right? So for today's session, I'm actually going to build your understanding about what international contract drafting is and how it is different from your domestic drafting or whatever pre notions you had about drafting in general, right? So I'm not going to make it really theoretical, but I'm going to make it a lot practical so that I get maximum response from you all and I understand that where is the problem that you won't understand, right? So let's begin with two legal problems, right? So, I'll explain you a very simple situation, right? So, take for example that we have a startup, right? Now, this startup is, let's say, building a product, right? Now, this startup is building a product and they're hiring some developers from some another country, right? To make it easier for you, let's say the startup name is TechSpark and this startup wants to, let's say, build a particular product. It can even be a software for that matter. And naturally, to build that software, they want to hire developers from some another country for that matter, right? So now the developer and the startup, they have agreed on the work, they have paid for it, and the product is also delivered. Like for example, let's say they wanted a software, the software is also been given to them. So everything seems very successful, right? Now what happens is, let's say now the company basically goes for investment, right? Now during the due diligence, like where the investor is asking a lot of questions and all of that, let's say the investor's lawyer comes to you and ask you, like as a startup, ask you one question, right? So that they would ask you that, can you show me the ownership of the software that you've prepared and everything for that matter, right? So at the first, the founders of the startup are really confident, right? They have all the payment records, they have emails, timelines, all the work they have completed, right? So everything is fine except one thing, right? So that one thing is that there is no clear ownership of that software or the code they have prepared, right? And suddenly that would become a serious problem for them, right? Because legally this is not a small gap, like when you do not mention about ownership, right? So I do not know about how much you guys have a experience in IP and everything for that matter, but just to break a little myth or like a bubble, if in case you would have in regards to IP, especially when you talk about a general worldwide view, right? So I'll give you a US example for that, right? So under your US copyright law, the ownership, it does not automatically transfer just because you paid someone, right? Let's say I am paying you to, let's say, prepare me a research report, right? So my own, like the ownership of IP would not automatically come to me just because I've paid to you, right? So you have to actually like look to a lot of concepts about ownership, like how does the IP would transfer and everything for that matter, right? So naturally I'm going to explain you everything to drafting and all of that, but I want you to know these concepts beforehand, right? So if we take our given example, so this particular startup would, like, maybe they have the working product, invoices, they have delivered all the codes for that matter, but still there is an uncertain ownership for that matter, and naturally this will affect a lot of things like your investment, your valuation, maybe your future licensing, and even the ability to, let's say, sell your business for that matter, right? So that's the first thing, right? The second thing is, like, let's talk about two companies, right? So I'm gonna build your base in regards to international clients, right? So let's say we have two companies in different current countries, right? So let's say one's from Germany, the other one is from Singapore for that matter, right? Now these two companies, like located in different countries, they have signed a contract, right? Now the relationship, let's say, breaks down, right? Let's say whatever agreement or the contract they had, it's not working anymore for them, right? So now let's say like a country or one company for that matter wants to sue the other country in their home country. Let's say Germany wants to sue Singapore in its own German courts, right? And the other one also, like Singapore also wants the same thing to happen, right? So now I hope you understand, the question will not be about what thing was breached. Now this, like, everything would center around one question, that where should we actually go for fighting this particular case, right? Or let's say whose legal system should actually decide where the court, like where the dispute has to be heard for that matter, right? So like when you talk about your international commerce for that matter, this question of forum, like forum is basically where you have to go to fight your case, right? That choice will usually be respected, like whatever you've written in your agreements, right? And if you do not write anything in your agreement for that matter, it creates a lot of confusion, that which place you want to go to, or where do you want to uh, file this particular case for that matter, right? So now before beginning with international contract drafting, I would have a question from any one of you, right? So what do you think, like out of these two problems, if you could understand it even a bit, that what do you think is more dangerous in real practice, right? If, like, for you, is it having no ownership in your agreement that's dangerous, and is it for you having no forum clarity, that where you have to go to fight your case, that's more problematic or dangerous? Like, what do you think is more problematic in the given situation? Yeah, and this, in this class there would be no wrong answers, so don't worry. Yeah, we got a reply. Okay, so we have people who says, like, we have one that says both not I believe both need to be addressed, I think. Yeah. uh then we have a few that says forum are much more problematic, right? So like, this is officially, I'm so great to get a response from you all, because this is officially where this course is beginning for all of you. So I hope you understand this is what international contract drafting is, right? And I'll even explain you how it is different from your domestic drafting, right? So when you talk about, like, per se international contract drafting, it's not just like a lot of people. I think it was the last session I took, like last course I took over international contract drafting, where they actually thought it's just like taking a template, like a domestic drafting template, and I'll just add a foreign party there too, right? This is not what international contract drafting is, right? So what we mean by, like, basically drafting agreements internationally is that we design a particular transaction so that it survives across legal systems, right? And in regards to, like, the question, the answers given by all of you in regards to which is more dangerous, not mentioning the forum or ownership, both of them are really dangerous, right? It all depends upon which particular jurisdiction you are approaching to you, and which more, like, which particular jurisdiction or the place is much more favoring to you or not favoring to you, in case you have missed that clause, right? And this is exactly what we're going to learn throughout this entire session, right? So I'm just going to clarify, my agenda with you all is not to teach you all the laws from A to Z, like pinpoint, like this is the section, this is the statute and everything for that matter. I'm going to tell you in each jurisdiction what is important, and let's say you get a client from that jurisdiction, what are the things that you have to keep in your mind in regards to when you're drafting the agreement, right? And naturally, everything is going to be practical for that matter, right? So as I've mentioned, when you design a particular transaction in your international contract drafting, you have to make sure that it survives across various legal systems for that matter. So today I would want you to, give a way, like, how do you think actually as an international drafter for that matter, right? So these are a lot of things you have to take into consideration, that what are the different court procedures, ownership assumptions, as I've cleared to you, like I took one IP course also. So a lot of people assume, so if I am paying you for a certain work, so naturally all of it will belong to me. That does not hold true, right? So I don't know if you're aware about your IP clauses. We actually divide our IP clauses on background IP, foreground IP. So everything is done in that grounds for that matter, right? So when you talk about today's session, or how do I take you through the initiality of international contract drafting. So here I'm actually gonna, teach you three layers, right? First, you should know how the cross border, like your international deals, should be broken down by a particular lawyer or as a contract drafter. So let's say you've got an agreement. Let's say one client is from UAE, the other client is from Singapore. How you're going to actually approach it in the first place? We're going to also, so the second step is going to be repeated, I think, in the coming session. So little attention would be given in that regard. So I'm going to tell you the three legal pressure points that repeatedly matter. So when you talk about forum, you talk about ownership and the enforcement of any agreement, right? And lastly, I'm going to show you basically that how like when you talk about all of this, how it actually sits inside an actual like architecture of a commercial contract for that matter, right? So before we go further, I have a question for you. Like, let's say when a client says to you that, we are hiring some overseas developer, or let's say we are expanding in another country, right? So what do you think the client is asking for from you? Like, let's say I am saying you that this is my company and I want to expand it now in Dubai for that matter. So what I'm actually expecting from you as a international contract drafter? Any idea? Okay, so see, a lot of you might think that, okay, as a contract drafter, I just need an agreement from you as a client, right? But that's not usually how it works for a client, right? The client actually is asking from you the entire transaction, like the entire transaction design for that matter, that exactly, Soumya, the legal clarity, like how you're going to break down the entire agreement and everything for that matter, right? So when we start with international contract drafting, here basically you're dealing with more than one legal system, right? And that creates a lot of questions in your mind, right? So it would be like, what party is doing what in that regards, who is getting what here, who is bearing the risk, and let's say what happens if things go wrong, right? So if I would actually put you through, we have like four structure. Just give me a moment. So we have four structure to any agreement, right? Like take it as a good advice, even if you're drafting your international like your domestic agreements for that matter, right? So here you have to check a lot of concept, like firstly the commercial layer, then you check for the legal relationship layer, you check for what are the risks involved, and lastly you would check about the enforcement layer for that matter. So whenever you're approaching the international agreements, these are the four layers that we have to always focus for in that particular regards, right? So here I have an example. So today's class, I'm really sorry, and I'd love to take a feedback in case you would want entirely theoretical or a lecture session. I would take it that way from tomorrow's session. So let's start with an example so as to make you understand things, right? So suppose there's a founder that comes to you and says that, let's say, for example, we are licensing a software to Singapore, or let's say we are using a UK uh, we are outsourcing certain development to India, right? So whenever you hear all these terms, they sound like, straightforward business instruction, right? And this is exactly where I think a lot of people make their first mistake, that they hear that, the first sentence that is, a business sentence is there. You'll pick a template and you start drafting. That is what we do. Like, I myself was from your end, I think, and this was the mistake I used to make, especially with the international clients for that matter, right? So when you are, approaching the international clients, we do not do that way, right? So you have to basically, structure your agreements. Like if you're a beginner, and if I assume that none of you have ever drafted an agreement, you have to ask yourself few steps bifurcated. It's just like how we used to prepare our moot courts in the law school time, right? We would bifurcate everything and then prepare a structure for ourselves. We go similarly in like in the same way when we go with the international contract drafting, right? So let's say if I tell you that there's a US company, right? And this US company is parenting with a Singapore company, right? Now, do you know enough to draft an agreement? I think, of course, you do not know a lot, like just by someone saying that I want to partner with a Singapore agreement, right? Now, why this is so? Because the word partnering is just a business language, right? It's not a legal architecture for that matter. So you need to know whether this is a reseller arrangement. And don't get overwhelmed in case you don't know anything about what this agreement is about. We're going to teach everything from A to Z about every agreement for that matter, right? So there are a lot of agreements. So maybe it could be a software license, maybe it could just be a referral relationship, or maybe it's something closer to a joint venture, right? So this is the first lesson I want you to take seriously, that a business label is not a legal structure. Let's say someone tells you to draft a white labeling, like I want to sell my product, like someone's product, and use my brand name. You cannot just assume things on your own and just pick a template and draft it. That's not how it actually works, especially in your international agreement for that matter, right? So here I just have a quick term before we go further. So do we have anyone here who know what SaaS are, like SaaS agreements in general? All right. So, see, I'll be using a lot of examples with SaaS, and I think you should know about SaaS agreements because they're quite in demand for that matter, right? So, like when you talk about SaaS in general, it's named as software as a service, right? So, in very simple terms, if I explain you what SaaS is, it's like a software that you do not, buy permanently, and you just own like one-time product, right? So what you do is you access it over the internet, and it's usually through a monthly payment or an annual subscription for that matter. I think the best example, like a layman example I can give you, is of Netflix, right? You do not buy Netflix as a company, you just buy a subscription of it, correct? So like same is for the case of Google Docs, Zoom for that matter, Canva, you have Shopify, right? So you do not own the software itself, you get the right to use it on the agreed terms for that matter, right? So this is why, like when you talk about the SaaS contracts, they are usually not a simple sale contract. It's not like you're selling something, right? It's more about accessing rights, the service levels, what is the payment model, the data that is to be shared, right? What are the limitations you have to put in regards to use and everything for that matter. So if I give you a very simple, like a one-line explanation to what SaaS means, it is basically renting a particular software through the internet instead of buying it outrightly. So I hope this concept is clear to anyone. In case of any doubts, any question, you're free to put it in the chat box, right? So let's just discuss the four layers for today, and start with like how it is different from a domestic agreement. And tomorrow we're going to start with your international documents like CISG, how it is going to be governed, and all the other like legislations or the soft laws for that matter, right? So the first layer, wherever you'll approach as an international drafter, would be your commercial layer for that matter, right? So when you talk about the commercial layer, now like when you're approaching the first stage of looking at any agreement, you do not have to think as a lawyer as of now, right? You just have to have one question in your mind, that what is the business actually trying to do for that matter, right? So I'll give you an example for that matter, right? Let's say there's a founder, and this founder is saying that we are licensing the software into Singapore. very clear, right, that somebody wants to license their software in some Singapore company and anything for that matter, right? But again, like when you see that one sentence about licensing it to Singapore, it can mean a lot of different things, right? So I've listed few here, that it could just mean like, I would have a question that when you're licensing someone to something, like, are you first like selling it directly to the customers, or are you selling it through a local company for that matter, or maybe it's just like a one time use, or it could also be like a SaaS, like a subscription, like a SaaS model, right? So each option would naturally need some different kind of contract for that matter. I hope you understand. So the first thing is, if you misunderstand this, can your contract still be correct for that matter? I'm really sorry, that cannot be correct. Like, even if you write a like a beautifully drafted contract for that matter, it will be wrong if the business understanding is wrong in the first place. So see, sometimes the client just give you vague terms like, draft this for me. So these are the questions that you as a drafter should always ask the client for that matter, right? I'll give you a very simple example. Let's say, we are using, somebody says, like a client says that, we are using a UK reseller now, right, for some of our work, right? Let me give a very like a simple example. Let's say I have a skincare company at my end, right? And now I want to sell my like products even in UK, right? So I would need a reseller or an agent for that matter, right? So like, let's say the company is saying to me that the client is coming to me and saying to me that I need a UK reseller. I have a UK reseller and I want to prepare an agreement for that matter, right? So now there could be a lot of question, like, is the reseller just finding customers for you in UK, or are they also signing deals on your behalf in UK, or can it like the reseller change the pricing of your skincare products? Like, these would be the questions that should actually come into your mind for that matter, right? And trust me, these are not legal questions, these are the business questions for that matter, right? So if I give you a sense of what I mean by commercial layer, it is that first understand the deal of the client, right? Then draft the contract, right? So it should not be the other way around, right? So in case you ever had this understanding that, let me just download this template and I'll work around it with it, it does not happen that way, right? So never start with the contract, start with the deal. Like, we as international drafters would ask a lot of questions to the clients business first, right? Like, what kind of deal they want to enter. None of here are the like legal questions I'm asking them. I'm just asking, how is your model gonna be governed for that matter, right? So just saying that if you start with a template, you force the deal into the document, right? And if you start with the deal, you actually built the right document for yourself in that matter, right? So if I give you the reseller example, like, what I mean by the right structure is, like, it means the right type of legal document that would be required in that regards, right? So for example, if I'm saying that we have a reseller from UK now, so firstly I have to clarify from the client that by reseller, what do I mean? Like, is that person a distributor? Is that person a reseller? Is that person an agent for me? Like, all these questions have to be clarified from my end to the client. So can I get a thumbs up in case this concept is clear, and then move ahead with the second layer? All right. Okay. So now the second layer is your legal relationship layer, right? So this is when you dissect your all the legal questions in that particular regards, right? So when you talk about like one deal, it is not always one thing legally. Like, it won't just mean like what we are trying to say legally as well, right? For example, I am saying that now we are all outsourcing all our development to India as a company, right? So okay, you might think that, all right, it's cool, I want to just prepare one agreement for that matter, right? But actually, if you understand it here, there could be like very different things that could happen, right? So naturally, you are sharing the information, so you would need a confidentiality agreement, right? Or maybe a confidentiality clause or an NDA for that matter, right? Secondly, you would be building services for that matter. So you tick mark in your mind that I would need a service clause in that regards, right? Sometimes you might build a code for someone, right? So the concept of ownership also comes here. So it's just the pointers you make, like, the rough page you make and you put all these things. You have to mention all of these things in your legal relationship layer, right? So this is not just one relationship you're defining, it could have many legal questions, right? So if you only draft for just the services and ignore the ownership part, like, I hope you understand what would happen. Like, a lot of problems would arise uh, at a later stage, right? So what I mean by the second layer is nothing should be assumed, right? So client says something that sounds simple, but you do not take things at just the face value. You have to break it down and check that what exactly is happening, what relationships are involved, what needs to be covered legally. That has to be seen at a second stage for that matter. The first stage, you have to ask the client a lot of questions in regards to the deal. Now, after that, you have to see that what all legal relationships or legal concepts are being attracted here for that matter, right? That, and why it is important to actually tell you all of this is because now is how I'll actually explain you all the clauses for that matter, right? Now the third layer would be your like risk layer, right? So naturally, once you understand the objective of the like business for that matter, and you like decode all the legal relationships for that matter, the next question would always be that, what are the things that can actually go wrong in my agreement for that matter, right? And like, more than that, I even feel that there comes a question that, who will actually bear the, risk when things go out of your hand, right? So like, when you talk about what things can go wrong, like, I've listed few points here if you could check. So a delay could come in our agreement, right? Let's say the client is actually not paying me back, right? Or he or she is actually delaying in giving me a payment, right? So I would love to ask you, so how would you tackle such a problem in your agreement? So can I have some answers from anyone that in case there's a delay, how would I counter it in my agreements? Okay, Hema says compensation. I think that's a great answer. I think the precise term would be that you ask an interest, like a late payment interest from the other person. So what we put it, like, let's say somebody is delaying the payment, we always add. So this is usually what, like, let's say you're like drafting from the service provider side, right? There's some, like, from someone who's actually delivering the services, right? So we actually always make sure that we add one clause that in case you are delaying my payment, it would be subjected to an interest of so and so percentage. And in case my payment is not cleared within 10 business days, so or like if let's say it's been happening so, like consecutively for 2 months or 3 months, you put a limit to it. It can also mean termination of the agreement, and then you can actually ask termination fee and everything for that matter. So these are the things that you have to take into consideration, right? I would also love to discuss the confidentiality leak for that matter, because we had a good discussion about it in a previous session, right? So I hope everyone here is aware about what a confidential information is, right? So when you talk about a confidential information, it's basically a company's or like, let's say two parties are sharing information that are very sensitive, right? So let's say it could even be a trade secret. Let's say Coca-Cola has a secret formula of preparing Coke for that matter, and they're sharing it with the other company for XYZ reasons, right? Now, this company, and they've actually signed an NDA together. So NDA is a non-disclosure agreement, right? Which actually puts a responsibility on the party who's receiving that information not to disclose it, right? So now let's suppose the other party has, breached that particular confidential information of mine, right? So what are the remedies I should put as the person who's disclosing the confidential information? Like, do we have any idea about it? Okay, so the remedy, like the first remedy, obviously we'll ask for compensation and all the payments, everything. That's a separate thing. The first thing, whenever your confidentiality has been breached, in case you've been reading agreements or contracts for that matter, you'll always see the word injunction, right? Termination, Hema, that's great. Like that would happen any which ways. Your agreement would be terminated. You could mention that it would mean like termination of the agreement, but I hope you understand your confidential information has been breached, right? Like it just means, let's say my personal information has already been out in public, right? It's like spreading like a wildfire, right? So even if you terminate the agreement, it's actually not going to be of any it's actually not going to solve any purpose for me whose information has been shared, right? For me, protection of that information was, very important, right? So let's say my trade secret, like my secret formula of preparing a particular recipe has leaked, right? So now first thing, okay, you terminate the agreement, you give me the compensation, everything is great, it's hunky dory. But what about the information that has been breached, right? I would want to put a injunction, like I would want to seek an injunction from the court that at least stop the information from spreading like a wildfire. So whenever you see a confidentiality clause, like the remedies clause to it, we usually put up that, the party is entitled to injunction with other remedies like compensation and all of that. So these are few of the things you have to take into consideration whenever you're drafting the agreement, right? So what I mean is that all of these risks create a clause, right? You just don't assume that the clauses to are standard. I'm just gonna like change the parties names and everything is gonna be like doable for that matter, right? So what I mean is the clauses, they are always a response to your risk, right? So you just like, let's say someday down the line you're drafting an agreement and you're clueless that what to draft. So these layers are basically for your help in that regard. So you understand, okay, these are the risks I know would be like relevant to my particular agreement. So I have to like add this in my agreement for that matter. Or let's say we are lazy drafters and we are copying a template online for that matter. So at best, what you can do is you can study that template and you can see what are the risks that are just being attracted in your case and just add those clauses for that matter, right? So your risk, on those basis of risk, you add a particular clause for that matter, right? And the last thing we have is the enforcement layer, right? Now the enforcement layer is so overlooked, right? And I think the last batch I got so many questions, like people were so like intrigued to know that what happens in these situations, that I think we would have spent 2 sessions discussing about the enforcement concept, right? So when you talk about the enforcement layer, this is where you ask a very practical question, right? This is that, asking that, let's say if my client is right, right, will that actually help me or not, right? So what I mean is like, I hope you understand, this is actually different from asking that who is right or who will win for that matter, right? So when you talk about the cross border work in that regards, even if let's say your like client wins, right, whatever you're drafting in your agreement, you won the case and everything for that matter, there would be still one very important question, which would be that can I actually recover anything from the other party or can I not for that matter, right? Because see, when you talk about domestic agreements in that particular regards, what happens with domestic agreements is we know that there is a lot of certainty, right? There's a uniform procedure that follows across, so it's all clear. Problem arises when you deal with international or cross border deals, right? And it is much more confusing when one party is from one country and the other party is from other country, right? So now you start asking yourself, or you start thinking that where will the dispute happen, or where are the other parties asset, will this like whatever I'm actually getting, will it actually be enforceable there for that matter? So everything is actually, put up very like strategically in your agreement for that matter, right? So let's take the same example for the like sake of clarity. Let's say your client appoints a UK reseller, right? Now, like, let's take a situation where the reseller has stopped paying me, right? But that reseller is still continuing to use my skincare like brand for that matter, right? Now I know I've clearly won, because see, the reseller is not paying me whatever money he's receiving from my brand, right? And but he's still, uh, using my brand. So I know I have a good legal claim here, but do you think that this is actually enough for me as a like the main person, as a like a manufacturer, or a like a manufacturer or a producer of the work, right? So it is not enough for me, because the real question would always be that where should I sue this particular UK reseller, right? Under which law should I sue this particular reseller? And what are the assets of the reseller that would be attracted, right? So this is the choice, or this is the steps that you have to follow as a contract drafter. Like, you have to make a decision ki, let's say two parties are there. I hope you have read certain agreements. Let's say the like one party is from Singapore, the other party is from, let's say, Germany for that matter, and they have put a very different law in their agreement. They've put English law for that matter, right? So there would be a reason why the person has put English law for that matter, right? So this is where the contract drafter has used a lot of strategies and understood the concept that, okay, English law is going to be favorable to me because of so and so reasons, right? Naturally, I'm going to show you, teach you all of that. But firstly, I want to like make you understand that this is what happens at an international level, right? So see, I'll tell you the thinking we as beginners have, right? As beginners, we always have this question that, do we have a case here or not, right? And if we have a case, everything is great for us, right? But when you like start approaching, like when you get into the practice, you would always ask the first question, that would be that, will this case actually lead to a little recovery or not? Like, if it is not leading to a recovery in this jurisdiction, which jurisdiction would be much more neutral or favoring to me as a party, right? So always remember, winning a case is one thing, but getting the result is another thing, and you should have to focus on both these steps for that matter, right? So if I bring all those four layers together and just give you a summary of what we have, build our concept up till now, is that, let's say there's a founder, and this founder comes to you and say that, we are outsourcing some development to India for that matter, right? So here, I hope you understand the biggest mistake you can make here is that, opening a template immediately and just put in the party's name and you're good to go, and just change the payment clause, like put the exact payment and everything for that matter. What you should actually do here is, like, if you talk about the commercial layer, you have to ask yourself that what is the company actually trying to do, right? So I'll understand the business deal. So they want a software built for the business from India for that matter, right? Secondly, I'll check now all the legal relationship, right? What is happening legally here, right? I will not just check the development of the software, but I will see that if there is any confidential information that would be shared, if there is certain services that is required from that particular, outsourcer, if there is any ownership that the other party is asking, or if there is any support later the other party needs, right? That I'll see. After that, I'll see that what are the things that can go wrong. Like, for example, delay can happen. Maybe some bad quality work would be given to me. So I have to protect that part of my clause itself, right? there could be ownership issues, so I have to add an IP clause, right? There could be payment issues, so I have to make sure that how I want to build my payment clause. There could be a data leakage in case there's a like a confidential information being shared, so I have to cure that part also. So this is how we approach our agreements as a international drafter for that matter. And lastly, we decide that where will the dispute go to, by which particular method we're going to resolve the dispute. Like, are we going towards litigation, are we going towards arbitration for that matter? Naturally, this is the thing you ask from the client, and if the client leaves it at your end, what you should do, this is what we're going to learn as we move ahead for that matter, right? So this is basically how you should think as a drafter, not just in clauses but always in layers, right? So like, if I tell you, this was actually what was like the only problem I would face while drafting the agreements was I could not understand what I have to draft. Like, I would know, like, knowledge I would have 100, but execution I would have 0, right? So this is like, these are the layers my mentor actually taught me and told me that this is how you approach an agreement in the first place, a given case or given proposal by your client, and then you build your agreement, right? Because every agreement is specific to your client's need. It cannot be any general agreement you copy from internet and call it your agreement for that matter. So please never jump to drafting. First understand the deal, break it down, and then draft for that matter, right? So if that's clear, let me know. We'll just do a little more about agreements and everything for that matter, so that tomorrow's class is much more easier to understand. In case anything you want to discuss, go back, or if anything is not understandable, just let me know. Shall I proceed ahead? Okay, Alfia, what we actually mean by SaaS is like where we are taking someone's services, but on subscription basis, right? For example, you're using Zoom, I'm using Zoom, right? So a lot of people actually subscribe to this particular, you're not owning Zoom, right? You're just taking services of Zoom. Sometimes we take a paid version of Zoom, or for that matter, I would give a better example. Something that you can understand is Netflix for that matter, right? So, and like, let's say you've subscribed to Netflix for that matter, right? And you're not owning Netflix for the first place. uh it's actually just subscribing to it. So SaaS deal is, it's just like when you go to gym for that matter, right? You're not owning the gym, but you are subscribing to the subscription, like subscribing to the services of a gym for that matter, right? So when you talk about SaaS, you use software over the internet, like you would install it like in on your device and everything, but you cannot buy that software. Like, for that matter, Microsoft also, you do not, like Windows for that matter, you do not own it. You can just buy the software, like you can buy the like installation or the subscription to it, but you cannot own it for that matter, right? For example, like you talk about Google Docs, right? You write the documents online, or Zoom, like you attend the meetings, or as I mentioned, Netflix, you watch the shows, right? So the software runs on someone else's server cloud, and you just access it via the browser, or let's say an application if you are using it. So you would just pay it monthly or yearly for that matter. So it's just like you're renting the software online instead of owning it for that matter, right? So whenever you talk about SaaS in regards to contract, it's not a sale of the software we're actually taking it. It's just like a service and a license to use someone's software for that matter. So here we do not transfer any ownership. We only get rights, like to access that particular software. So just to give you an example, an hypothetical situation, let's say my company is getting into a deal with Netflix, and we want to take services of Netflix and everything. So we get into an agreement with Netflix of SaaS, like we draft a SaaS agreement, right? So there, or else I'll give a better example. Let's say we want some internet, like you see Amazon and everything. Sometimes they say WhatsApp is down, right? Like WhatsApp is not working, or Instagram is not working, right? So there's a downtime these like companies face. So it's basically everything is governed in your SaaS agreement. Like in your SaaS agreement, everything the parties tell, like this is the time where the companies would have downtime. If the downtime is there, they will cure it in so and so time. We are just giving you rights to access, maybe browsing and all of that. So SaaS agreements are always subscribing to a particular service agreements. They are not more about buying that services. So when you talk about the sales agreement, your purchase agreement, there you're actually buying the ownership of that particular product in hand. As we move ahead, I'll actually explain you through like examples. I think we have an expert who would take your SaaS session. So naturally it will be much more clearer. But as a beginner, just understand, when we are taking someone's services rather than just owning it up, that's what we call as SaaS for that matter, right? So I'll just discuss this one last topic, and we'll take it from there tomorrow. So now let's just understand that how a deal becomes an entire legal structure. So here I'll introduce few agreements so that you can understand what each agreement is about, right? So let's imagine that we have a US SaaS company, right? Now this SaaS company would just be a service, like a subscription, so like given as a service to other companies. And this SaaS company basically wants to expand in Southeast Asia for that matter, right? So when you take it from your client's perspective, who would be the founder of that company, they would have only one question, that how do we sell in that particular region? Like, for example, Microsoft is saying that hypothetically that we want to expand now in Southeast Asia, right? So they would just be like, how do we sell our services there for that matter, right? But now you are a drafter, right? You have to draft an agreement for them, right? So you have to legally think that this thing, that how they can sell there, could have a lot of like answers to it, like can be required for it. So like, for example, the first one would be the direct contracting one, right? So direct contracting means that the company sells directly to the customers, let's say in Singapore or Malaysia, like any South Asian company for that matter, right? So when you talk about somebody directly, forget about SaaS agreement, right? Forget about like, just imagine there's a company which actually wants to now expand its business in some part of the world for that matter, right? So they can have, like, as a contract drafter, you could have various options to draft, right? First, you can think about direct contracting, where the company would keep full control of the customer relationship, right? So you will prepare a document that will include whatever implementation would be, the privacy clauses would be, the limitation of liability would be, like payment and renewal clauses would be, like basically a lot of control would be of the company itself, right? So here the company is dealing directly with the customer for that matter. One, you could have this, right? The second agreement you can actually, or the second route you can go to, is your reseller route, right? So instead of selling directly, the company, what it does is it appoints a local business, like a middleman in like Singapore for that matter. So this is like how I explain you, like this is very prevalent in your skincare industries, right? So what they do is, like, let's say there's a skincare brand from India for that matter, right? Now this skincare brand wants to expand in UAE, right? Or Dubai. Let's just focus on one particular region. So let's say it wants to expand just in Dubai for that matter. So one the option they have, that they can directly contract with the customers there, like set up there as a brand. But I hope you understand there could be a lot of problems that the company could face, because they would not be having a lot of awareness about Dubai laws, the customer structure and everything. So a lot of research would have to go there. So, and a lot of capital, like a lot of expenses could go there. So sometimes they choose the route of a reseller, right? So instead of selling directly to the customers, the companies appoint a local business particular region, right? So now that like business would help the market and resell that particular product for that particular business, right? So this is reseller. So here, like when you talk about a reseller agreement, the entire structure would change, right? You would have to decide that what is the pricing that you have to share with the reseller, what would be the like how much can they brand your like or market your product for that matter. Is there any territory restriction that you want to put in your Dubai branch? Like, is there any products you do not want to sell there? What would be the termination rules for the reseller, that on what terms we will end this particular agreement, right? So here, what happens is the company is not just selling, it's actually building a sale channel via which they are selling for that matter, right? Now, here, the third kind of structure also you could think about is the technology license route, right? This is more on the SaaS line. So what it actually means is, like, instead of selling directly or using a reseller for that matter, the company gives a local business the rights to just use its platform. So it's just more on the SaaS line. So I just feel you might get confused on the SaaS line, so I'll ignore it for now. So let's just see, like, you could have two options when the company wants to expand in the other region, right? Either as a company you can go about with it directly to the clients, or you could maybe just appoint a reseller for that matter, right? So, like, if you think, like, if you do understand a little bit of it, out of these two agreements that we've discussed, the direct contracting part and secondly the reseller agreement, which one do you think is easier for a company to grow faster in that particular region? So is it direct contracting or a reseller model? Any idea about it? Like, when you compare the direct contracting agreement and reseller agreement, what do you think is much more like flexible or beneficial if the parties want to actually grow in a different region for that matter? Okay, no, Alfia, it would not be direct uh, contracting for that matter, because uh, you would actually have to build a lot of base first. See, like a brand builds a base in a particular country where they're setting up, right? Let's just stick to skincare as an example, because I think everyone would understand it better. So if I'm launching a skincare brand, like it's the first time I'm actually launching this brand in India, right? So I have to do a lot of PRs, promotion, build good base with the customers so that they find the brand to be very reliable and everything, right? So it would be a good process, right? I as a company would get a lot of control, but I hope you understand, it's not going to give me a fast growth, it's going to be a slow constant growth for that matter, right? So usually when companies want faster growth for that matter, we usually opt for a reseller route, right? So here you don't need to build your own presence in that country. The reseller already has their local customers. They have a lot of knowledge about the market in the first place. They know about the distribution network, right? So you get a faster entry in that market, and the upfront cost is also quite lower, so the growth becomes much more faster and lighter when you talk about the reseller agreement for that matter, right? And naturally, like, if to answer your question, like, out of these two agreements, which one do you think would give most control to the company? Is it the reseller agreement or the direct contracting agreement? Like, in like between both these agreement, which one would actually have like, where would the company have more control, by directly contracting with the customers, or like appointing a reseller here? Any idea, anyone? Okay, so here, yeah, yeah, we had someone.
Isn't it a 50-50 situation?
How come? Like
Like
more control in regards to more having more control.
the direct would be more control, but then the market would be smaller, and in the reselling, the market would be at the larger end, but the
Uh,
control would be little less.
oh no, I think you're misunderstanding the question, right? I'm asking, given a situation, let's say the client wants to, uh, you know, like broaden or now like set up their company even in like some state abroad for that matter, right? So what do you think out of these two agreements, like a direct contracting agreement or reseller agreement, would actually out of these two would actually give more control, like more upper hand on the brand? Like out of these two agreements, which would be the agreement?
Direct.
Direct, right? This is what I'm actually saying. Like this is actually how you make a understanding that okay, this would be the agreement that I have to draft, where the like brand clearly says that I want to have an upper hand, right? I want to have more control, right? Naturally you can also prepare a distribution, like when you talk about a reseller agreement, like we will learn about distribution agreement, and I'll teach you from both the ends, like when you are the main manufacturer and when you are the reseller, you can put like unfair terms on the reseller if the particular region allows, but any which ways the other party is also there to have a transaction, and they won't just bow down to every clause that you put in your agreement, right? So when you talk about a clause that gives you much more like an agreement that would give you much more control, when you talk about a cross border deal, it would always be a direct agreement with the customers, like when you set up, give a like have a base in that particular country all by own, but again it would have its own nuances, like a lot of money has to be spent, a lot of R&D has to be done in regards to research primarily has to be done in understanding the customer market, then you have to make a market entry, so a lot of compliance checks and all of that has to be done. So these are the things you basically tell your clients, and then you move ahead with drafting your agreement for that matter, right? So I'll just discuss one last little concept for today, and then we'll call it off for today's session, right? So let's just sharpen like this a little more, whatever we have done up till now. So one very common mistake is that we think that we just need, like if there's one deal, we just need one agreement and we are good to go, right? So I'll just tell you what happens in reality, right? This is actually never true, right? So let me actually give you a very simple example. Imagine that there's a startup, and the startup is, let's say, building um, a SaaS product, right? Something where you subscribe to it. Like, let's say they are building a Google Doc for that matter, right? So, or like some tools for that matter, right? So now what they do is they hire an overseas team to build that part of the software. Like for Google Docs, they're actually hiring a team outside, like overseas, to build that particular software, right? Now, at first, this would look really simple that we are actually getting our software built from outside, right? But again, if you think in layers and if you understand, a lot of legal relationships are being assembled. So now, since I think we have developed quite a base of it, can you tell me that when you are actually having a deal with someone else, can you tell me the legal things that would be involved there, like relationships for that matter? Any brief idea? It would be did here. So one part is always that your confidential information is being shared, right? So like first thing is that your information is being shared, right? So like before any of the work it starts, the company has to share the product idea, the features, the designs for that matter, right? Now this would always create a confidential obligation for that matter, so you would need a separate NDA. So you would have to tell your client that what are the informations you are sharing. So if it is a confidential information, for that you have to draft an NDA. You have to tell your client that will a small confidentiality clause suffice, or do we need a separate agreement for it, right? Coming to the second legal relationship we can have in this given situation is that, let's say now the actual work begins, right? The team is building the software for you, right? So naturally a lot of work, like you would have requirements in checklist from that particular like service provider, that we need so and so work like in so and so order and everything, right? So you would need a develop, like these are just, forget about development agreement, you would need a service clause for that, right? And I think you should never skip this. Like I think I started my session with this, is about like, okay, let's say you've hired me to prepare a code, right? But we have not mentioned anything about who's going to own the code, right? To you it might be like ipso facto you going to own the code because you are paying to me, but we're mentioning it in the contract, right? And if we talk about the international custom rules, it is never a rule that if you're just paying for the particular works, then the ownership lies with you. You have to specify it in your agreement. So never miss, at least this is one thing you should take from this class, that always ask the question about ownership here. And lastly, if it is needed, like sometimes after the delivery you might need certain support from the same team that's building your software. So fixing of certain bugs, or maybe updating a feature, or maintaining that particular product, or sometimes let's say the product is facing a power outage or downtime for that matter. So what are the remedies, or what are the support you can provide me in that particular regard? So these are the legal relationships, because we need to focus on that, because we have to build our agreement on these clauses for that matter. So tomorrow we're going to actually start with, I'll actually show you like the entire anatomy of an agreement, like what are the different parts of an agreement, the recitals, preambles, the clauses and everything to it. And we'll start with CISG tomorrow. It's like an international governing law. We'll like learn a little bit here and there about it, and start with the drafting part of US as we move ahead. So I think that is it for me from my side for today's session. In case of any doubts, queries, feedback, please you're free to let me know and put it in the chat box. I'll actually send you a PDF about what I've shared, like what I've discussed. There's a slight thing, like the PPTs I actually use are my own IP, so I cannot share it in the group. However, I still allow the students, if in case you want to take a screenshot or any which ways, you would have a recorded file with you, so you can any which ways take a screenshot or refer to it. I cannot, however, sadly share this PPT, but I'll share with you the PDF of whatever we've discussed today right after the class, like by the end of the day today. All right. Is there any other doubts, or shall I end the meeting? All right. I'll take that as a yes. Thank you so much, everyone. And I'll see you tomorrow, same time. Bye-bye.